Welcome to this presentation on non-fatal offences. For Joseph Chamberlain students, we're talking about component 2. So make sure that you've got your booklet to hand because we will be referring to it from now on. So what I'd like you to do first of all, Joseph Chamberlain students, is have a read of pages 3 to 5 in your booklet, and this will give you an introduction to the key points that we're going to be looking at. So that'll give you a good introduction to what we're going to be doing over the next set of presentations. Now I'd like you to turn to page number 8. You're going to need a pen. You can alternatively use the electronic copy of this document that I've put on Google Classroom, up to you. So first of all, I'd like you to have a look at each of these pictures, and I'd like you to consider what's the difference between the two, and is there a crime in either one? Let's have a closer look at that first one. As you can see, you've got little children who are wearing Halloween costumes. They're quite sweet and they're certainly not threatening, except that little one on the right, not sure about them. If you look closer at the other picture, you'll see that it's also a Halloween costume, but it's on a bit of a different scale. So if you saw this individual jumping out from behind the bushes, then that really might frighten you. And that's what I'd like you to think about. So the little children, they're not going to appear threatening, they're not going to feel threatening. Whereas this person would know that if they jump out from behind the hedge, dressed up in that get-up, then they could cause somebody to fear immediate unlawful force, and therefore they may be liable for an assault. So I'd like you to take a moment just to refresh your memory of the definition of assault. So you will have found that assault can be found in the Criminal Justice Act 1988 under section 39. It's also found under common law. So the definition, the actus reus, is causing your victim to apprehend the immediate application of unlawful physical force. So there's no requirement for physical contact, and if there was physical contact, it's actually more likely to be a different offence. The mens rea is intention or recklessness as to causing your victim to apprehend the immediate application of unlawful force. Now please notice, apprehend means fear. So you either fear or you apprehend, and actually those words are used interchangeably. What you don't do is apprehend fear, because that would be fearing fear, and I don't even know what that is. That's some sort of philosophy that's way beyond me. So the mens rea, intentional recklessness as to causing the victim to fear immediate unlawful force. It's essentially intention or recklessness as to causing the actus reus. And if you're concerned or worried about mens rea, go back to the previous video, which is about mens rea, and look up your different levels. So direct intent, oblique intent, recklessness. So just some key bits about assault. So we're talking about fear with no contact. Doesn't necessarily have to be a positive act. Words or silence can be sufficient, as in our island that we'll look at in a moment. And we'll look at the definition of immediate in a second. So the key cases that we're going to look at are Smith and the Chief Superintendent of Woking Police, Aaron Island and Aaron Venner. You can flick back in your booklet to pages 6 and 7 if you want to have a look at those, or you can do some Googling. So Smith and the Chief Superintendent of Woking Police is one of the leading actus reus cases, and it tells us that no words are necessary. In this case, the defendant stared through the victim's bedroom window. She lived in a flat, she lived on the ground floor, and she was understandably very frightened. And the question was, what was immediate? Because of course the victim was on the other side of the window. He couldn't immediately hurt her. And the court said, well, we'll say that immediate means imminent, as in the very near future. One of the key facts that law students always seem to remember about Smith is the fact that our victim was wearing a pink nightie, something like the picture that you can see. So if we look at Aaron Island, in this case, our defendant was making silent phone calls. So he was picking up the phone, dialing a number, and then not saying anything, which really frightened the victims. And the court also held that this was sufficient. So he didn't make any threats. The mere action of making the phone call and allowing it to ring out and then not saying anything was sufficient. So the action that can be taken can be really, really, really quite minor, as long as it has that impact on the victim. So your defendant does something and it has the impact of causing your victim to fear immediate unlawful force. A similar case which you might want to have a look at is R and Constanza, in which our defendant wrote the victim 800 threatening letters. Some of them contain threats, some of them just contain nonsense, but nonetheless it was held that this was also an assault. Clearly our defendant knew where the victim lived because they knew how to address the envelope, and that was sufficient for the assault. So those were your actus reus cases. I'd like you, it's a bit of a squeeze on page number 8, now I look at it again. I'd like you to squeeze in at least Ireland and Smith and Constanza if you can, and then we'll have a look at the case for the mens rea. So the mens rea case for assault is also the mens rea case for battery, which is quite useful, and it's a case called R and Venner. And the mens rea for assault is proof that the defendant intentionally or recklessly applied force to another person. And it also says that it's the same mens rea for assault. So Venner says, this is what you need to take down, Venner says that recklessness is sufficient for an assault. So this is a bit of an old picture now, I appreciate that. But this was one of these scary pictures that went around on the internet a little while ago. Could this be sufficient for assault? Having a look at your actus reus and mens rea that you've just taken down. So what we're going to do now is have a look at some of your scenario questions. Yep, you are ready to go on a scenario question. So Joseph Chamberlain students, you'll see at the top of page number 10, there is Antonio. He wanted to go out with Maria, and every day he telephoned her, stood outside her house, sent her cards or flowers. She was afraid that he was going to hurt her, and she just wanted to be left alone. So what I would like you to do is I would like you to state, explain, apply whether this is an assault. So this is how you're going to do it. You're going to have an introduction, and your introduction is the same with a small tweak. The bits that I put in red are where your answers are going to vary depending on the actual scenario. So due to the level of injury or lack thereof with the assault, the offence that the defendant may be liable for is, insert name here, assault in this case. So you'll start with the actus reus, as you always do. You'll state the actus reus, causing your victim to fear immediate application of unlawful force. You'll explain it with a case, so as in Smith, in which the defendant was staring into the victim through her window, she feared he would hurt her imminently. Do you see what I've done there with using the key words imminently? And then apply. So in this scenario, Antonio appears to have the actus reus because his actions made Maria fear immediate unlawful force. So if you notice, you've got key elements of the actus reus. So you've got what the defendant did, and then you've got the impact on the victim. And both of these are picked up in my application. So moving along to the mens rea. You've got to state it, intentional recklessness to cause the actus reus. Explain it with the case of Venner, in which the courts confirmed that recklessness is sufficient for assault or battery. And then apply. So thinking about, is it direct intent, oblique intent, is it recklessness? Now I've said, and feel free to disagree with me here, that Antonio had oblique intent because we know it wasn't his aim or purpose, so it couldn't be direct intent. However, if you send scary letters, if you send cards and flowers, stand outside somebody's window, phone them every day, you know that it is virtually certain to cause your victim to fear. And that is how you answer an assault application question. Simple. So now that you've done Antonio with me, on your booklet you've got Bruno, a former heavyweight boxer, practical joker. One evening in the pub he pretended to throw a punch at a stranger, so he's making a sort of vague punching action, but he's a former heavyweight boxer, he's going to be a big guy, and the man collapses in fear. So that's the next scenario. And then after that you have Carl, who almost cut right through the thumb on his left hand whilst chopping wood with an axe in his garden. He was now waving the axe around in the air, jumping up and down and screaming loudly, and a passerby is terrified he's going to attack her. So considering those two scenarios and using this structure, it's exactly the same structure as we used for Antonio, but Antonio has been taken out. I would like you to state, explain, apply the actus reus and mens rea of assault for both Bruno, the former heavyweight boxer, and Carl, the guy with only one thumb. So now we're going to move on to battery. So if you can open up your booklet, please, back to page number 8, and we're going to go through the law that you need for that. So refresh your memory about what a battery is. Have a look on pages 6 and 7, or use your mobile device to have a research. So battery, again, it's a common law offence, but it can be found under the Criminal Justice Act 1988, section 39. The actus reus is the application of unlawful force, and the mens rea is intention or recklessness as to applying that particular force. So this is your quick start introduction to battery. The first and most important thing is no injury is needed. And in fact, if you had an injury, then it wouldn't be a battery, it'd be a more serious offence. The case of Cole and Turner that we're going to look at in a moment tells us that it can be the slightest touch. Fagin, that yes, we've come across before, yes, it was that Fagin, says that battery can be a continuing act, and it can also be an indirect act whereby the defendant doesn't actually touch the victim, as in the case of Lyndsay. So if we look first of all at Cole and Turner, so you're going to be recording these cases, page number 8, under the battery section in the box underneath where it says actus reus. So Cole and Turner was from 1704, and the question was about, that the court was presented with, was could you unintentionally cause a battery? So if you knocked into somebody, if you grazed up against somebody, could that be a battery? And the court said no, it must be at least a touch of another person in anger. Now, the phrase in anger in 1704 didn't mean if you were angry. What it meant was with a level of intention. So I'd like you to stop for a moment, pause the video and have a look for these key cases that we're going to look at. So R and Thomas, Fagin and MPC, you've come across that one before, and R and Venner. Yep, the same Venner from above. So R and Thomas, first of all. In this case, a man touched the hem of a girl's skirt. So the hem is the bit which just goes around the bottom here, and it you turn over the raw fabric and stitch it up to make sure that your fabric doesn't fray or anything like that. And it was held that touching just the very, very, very bottom part of her clothing was sufficient for battery. There was no need for physical contact to the person's actual body. In Fagin and MPC, our defendant accidentally drives onto our police officer's foot. There is your actus reus. And when he realises that he was on the police officer's foot, he swore at the officer and told him he could stay there. I've slightly changed the wording that he used. And that's where the mens rea took place. So this is coincidence of actus reus and mens rea, isn't it? The actus reus takes place here when he drives onto the officer's foot. But the incident continues, it's one long act until he develops the mens rea. If we look at Hasted in the DPP, this is a horrible case which illustrates an indirect battery. In this case, a man punches a woman twice in the face and she drops the child that she's holding. Now, it's a toddler and it's annoyed, the toddler is, but it's not badly hurt or anything like that. So the child hits its head on the floor and the defendant is charged with battery of the child. And the case held that you can have an indirect battery. It didn't matter that a defendant didn't touch the baby. That was sufficient. Lyndsay is, shall we say, it's a case that demonstrates battery with a weapon. Our defendant is caught shoplifting and is detained in the store manager's office. During a struggle, he spits in the police officer's eye. That is disgusting, disgusting, disgusting. But the case holds that spitting is an indirect battery, and it's seen in this case equivalent to a weapon. And Venner, again, is the case that you need to go in the mens rea box. So the mens rea of battery is proof that the defendant intentionally or recklessly applied force to the person of another. And it's the same case with assault. So this is what the judge said. So to do an act deliberately hardly needs explanation. If you see somebody in front of you and you deliberately kick him on the knee, that's a deliberate act. No two ways about it. That it's an assault, but it could equally be an assault if you are lashing out, which is what happened here. Knowing that people are in the neighbourhood, meaning close by, or that there is likely to be people in that neighbourhood, and in this case, it is suggested that he had two people by his arms and he knew that he was being restrained as to lead to an arrest. If he lashes out with his feet, knowing that there were officers about him and knowing that by lashing out he would probably or likely to kick someone or hurt his hand by banging his heel down on it, then he is equally guilty of the offence. Venner therefore can be guilty of the offence on count 3 of the indictment if he deliberately brought his foot down on Constable Spencer's hand, or if he lashed out simply reckless as to somebody who was there, not caring an iota, that's a good word that is, meaning small, as to whether he kicked somebody or brought his heel down on the hand. So that's what that picture was about. You've got your defendant who breaks a police officer's hand whilst he's being arrested. So let's have a quick review. I'd like you to have a look back through your booklet, focusing mainly on page 8, and I'd like you to try and think of 3 differences between assault and battery and 2 similarities between assault and battery. So, as we mentioned at the start, a defendant is quite often charged with common assault, which is a combination of assault and battery. Therefore, do you think that the individual offences ought to be scrapped? So now we're going to have a look at some battery scenarios. Joseph Chamberlain students, you will see 4 on pages 11 and 12. So we're going to look together at this scenario. Gordon deliberately tripped up Tony as the 2 men were walking side by side down the street. Tony fell but suffered no injuries. So your introduction is going to be, due to the level of injury or the lack of injury, the offence that the defendant may be liable for is a battery. You're going to state the actus reus being the application of unlawful force. You're going to explain the actus reus with the case of Cole and Turner, the slightest touch can amount to battery. Now it may be that one of your other cases, such as Thomas, may be more relevant to later scenarios, so you can always swap it for that. Or best practice would be more than one case if you can get that written in the time. And then finally we apply the actus reus to the scenario by saying, in this case, Gordon applied unlawful force by tripping Tony up. The mens rea, we will state the mens rea is intention or recklessness to cause the actus reus. We will explain with the case of Venner, which confirmed that recklessness is sufficient for assault or battery. And we will apply the mens rea to the scenario. So thinking about, is it direct intent, oblique intent, or recklessness? So I've said Gordon has direct intent. It's his aim or purpose, as in Mohan, was to apply unlawful force and he got what he wanted. He deliberately wanted to trip him up and he did. Or I suppose you could say it was oblique intent, where the outcome was virtually certain and he knew it, as in Aaron Woolin. Either way, we can say that he is liable for the offence of battery. So now you can have a look at some of the other scenarios. You've got this one with Grant, who thumped Phil in the chest, causing him to fall into Barbara. And we'd like you to consider the possible battery against Barbara. Now you've also got transferred malice there, so you'll need to state, explain, apply that as well. Dennis was running down the road chasing a bus. He raced around the corner and saw a crowd of young men in his way. He tried to avoid them, but in his hurry brushed past one of them and no harm was done. So you may well have the actus reus of a battery there, but does he really have the mens rea? And finally, Fiona is a waitress in a hotel bar. While serving a customer at one of the tables, she tripped over an umbrella and poured a bowl of minestrone soup down the back of a lady, and it ruined the lady's jacket. Minestrone soup is a kind of soup. You can look that up later. Again, she may well have the actus reus, but does she really have the mens rea of the offence? So that's all for assault and battery. So you should now be able to state the law, explain it with a case, and apply it to scenario questions. See you next time for actual bodily harm.